Transfiguration Church. It is a fabulous place. We're located on New Hampshire Avenue, right where the ICC intersects New Hampshire Avenue. We've been doing services by Zoom, and we've been very blessed having Reverend Kent Marcoux with us. He joined us recently and his technological abilities has been fabulous. So thank you, Reverend Kent, for everything that you have done for us. With respect to myself, let me see how I'm going to, there we go. All right, so just so that you know, there's my email address and phone number. And please feel free to email me questions even after today. Call me with any questions you have. I am working throughout the pandemic. We've been very busy. Thanks to technology, we're able to keep doing what we're doing. Just as a little bit of background, as you can tell, my accent is from Queens, New York. I came down to Montgomery County to attend American University Law School. And I then joined a firm in Tacoma Park, became a partner there. And then in 1998, Elliot Andelman and I created Andelman & Flynn. And we're located in Silver Spring, and we also have offices in Rockville. We do disability benefits work, any type of disability benefits. And we also do family law. And now with the pandemic and everything happening, people have a lot of questions about wills, trusts, powers of attorney, healthcare advanced directives. And that's why we're doing this seminar today, is really to get the basic information to you. Remember, to ask a question, use the Zoom features of chat and Q&A. Feel free to look for those now so you have them handy. Some terminology. I think everyone has heard the words last will and testament. We'll probably just say wills to keep it as our shortcut. Power of attorney, POA. Whenever you hear POA or see POA, we're talking about power of attorney. And Healthcare Advanced Directive, HCAD, you'll see that in my PowerPoint slides often. That stands for Healthcare Advanced Directive. And let me just say that what's most important is what I will be discussing is Maryland law. I know we have a lot of New Yorkers and others on with us, which is fabulous. But if you have a specific question about New York, you need to ask a lawyer who's in New York. Just because I have a New York accent does not mean I'm qualified to answer New York questions, okay? So, but a lot of this does apply up by where you are. So, but definitely everything I say today is how it is in Maryland. Just to go through some more terminology, there are different types of trusts. There's the testamentary trust, which is the type of trust that your will creates. Just by creating a will, you can create something called a testamentary trust. And that's a trust that will then take effect upon you passing away, and it's pursuant to the terms of your will. And we'll get into that a little bit more. The other type of trust that we have is revocable trust, and as opposed to irrevocable trust. They actually become entities of their own. You can do some really cool things with trust. Revocable trust means just that. You can always revoke it, meaning void it, end it, terminate it. Irrevocable trust is exactly what that word means. It's irrevocable. And you really want to be careful if you ever thinking about doing an irrevocable trust. Very useful if you want to do Medicaid planning, but you have to be very careful with that. The other type of trust, I'm sure many of us has heard, is special needs trust. And that's really useful when you have someone who is receiving government benefits, perhaps a child or an adult who is disabled. And if they're receiving government benefits, they can't be wealthy, but you can actually create a trust for them where they are taken care of. They cannot have any control of that money. And it's very useful for you to create if you know someone who is receiving government benefits, but you want to leave an inheritance to them. Taxes. We absolutely need to cover taxes in the beginning, so then everything else that we talk about fits into place. You have inheritance taxes and you have estate taxes. Inheritance tax. That is the tax that the people who are inheriting from you, your beneficiaries, would pay. And in Maryland, remember, every state is different when it comes to inheritance taxes. But in Maryland, if the beneficiary is a spouse, or even is your spouse a child, a spouse to your child, sorry for that typo in my slide, a grandchild, a parent, or a grandparent, they do not pay any inheritance tax. So many times people say to me, well, why should I get married? We're doing fine, you know? I'm with someone forever. Maybe you have children together, maybe you don't. And they say, well, what's the benefit of getting married? One financial benefit, I know we absolutely have our religious and spiritual benefits of being married, but a financial benefit of being married would be that when you inherit from your spouse, you do not have to pay that 10% tax, which is a lot. The other type of tax is the tax that your estate would pay. And if you remember going back 5 and 10 years ago, everybody was doing living trusts because they wanted to avoid estate taxes. Well, now the federal estate taxes only kick in if your estate is worth more than $11.4 million. And your Maryland estate taxes currently only applies to estates if your estate is worth more than $5 million. Every state is different. And if you notice, I'm using the words currently because this could change at any time based on the administration that is in office, whether it's the federal government or the Maryland state government. This could always change. The trend for the past 10 years has been the threshold has been going up, 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 but it can absolutely change. And that's something you always want to keep in mind. If you hear at any point, suddenly these high thresholds go away, my advice is you definitely talk to an attorney about finding out how it might apply to your estate. Now, what is included when you're calculating the value of your estate? I have some clients who say, I will never reach $5 million. But what I tell people is you do want to look at what it is that you and your spouse own together. If, as in most married couples, when one spouse passes away, they leave everything to the other spouse, or they jointly own things. And then when one spouse passes away, it all is then owned by one individual. When calculating what is in your estate, you're going to include cash and personal property, stocks, bonds, and other types of securities, real estate, the value of your real estate, wherever your real estate is owned, trust and retirement accounts, life insurance. This is something many people forget to look at. What we're looking at is what is the death benefit if you have a term life insurance policies? What is it that your beneficiaries would receive? It's that amount that gets included when we're calculating the value of your estate. Business interests, which many times your business might have to be valued at the time of you passing away. If you own a business, you might want to get it valued now, so at least you know how much is it worth and how much will it be worth if and when you pass away. And death benefits from pensions and annuities. That's another aspect that many people forget is included in your estate. Also, now is the time not only to be thinking about doing your will, your power of attorney, and healthcare advance directive, but what you also want to do is look at your retirement accounts. Look to see who is the beneficiary. Is that who you want to be your beneficiaries now? So you do want to look at that to make sure you name a beneficiary. Also, if you name a beneficiary in your retirement account, that money doesn't go through probate. Your beneficiary could then receive it directly from your retirement account. And that's why I tell people, don't have your life insurance policies and your retirement accounts have as the beneficiary your estate. I know many people do that. They say, I leave my life insurance policies to my estate and let my will decide how it gets distributed. Then it's going to be in probate and it will take time for the people to get the money. Instead, really think about who, name specifically who you want to be the beneficiaries. You could say that I leave it to my children in trust and name a trustee. Then the person who's named as the trustee can then control those funds for the people that you want, such as children, to benefit from that money. Now, if you are inching up toward $5 million or you're over $5 million, there are ways that you can avoid Maryland estate taxes if you take steps now. And this really fits into estate planning. Estate planning doesn't have to be complicated. You have the right to give gifts up to $15,000 to an individual, as many individuals as you want each year. As a spouse, you could gift up to $30,000 to any individuals you want, but the way you do it is each spouse is giving that $15,000. If it's coming out of a joint account, it will be attributed as each spouse is making a separate gift. So if out of the joint account, a spouse is making a gift to their child of $30,000, you're not triggering any gift tax returns so long, because it'd be attributed as $15,000 for each spouse. Now, if you did give a gift more than $15,000, you don't pay taxes on that, but you do have to file a gift tax return. So, but as long as you're making gifts of only up to $15,000 to individuals, you do not even have to file a gift tax return. And you can do this as many years as you want and to as many individuals as you want. Certain provisions that your will is going to contain. One is appointing the personal representative, also known as an executor. In Maryland, we use the word personal representative. This is the person who is going to, we say, marshal all the assets. Basically, you're going to take all the assets and put them into an estate account. It could be multiple accounts, but you move all the assets into the estate, and then the personal representative is responsible for making the distributions. They are also the ones responsible for going through all your personal effects. So you do want to appoint someone who you absolutely trust, who is organized, who is financially able to deal with multiple accounts and accounting, and someone who is familiar with you, because better that than having a stranger going through all your papers and your books and all your finances. I do tell people when it comes to personal representative, I discourage appointing co-agents or co-personal representatives, meaning two people. If you do that, then both people have to sign all the documents and they have to agree on everything that is being done and the way it's being done. So I always tell people name one personal representative, but certainly name an alternate in case for some reason your personal representative is unavailable, is not feeling well, is out of the country, or maybe they're just not up to the challenge. Sometimes when someone passes away, we don't know how someone is going to react, and some people do shut down. So you do want your personal representative to be someone who is strong. Another part of your will, obviously, is your bequest. How is it you want to distribute your estate? As I tell my clients, just tell me what you want to do, and then let the lawyer figure out how to put it in the legal terminology. Do not start throwing around words like per stirpes, per capita, nunc pro tunc, anything like that. Instead, just tell your lawyer what is it that you want, and they will figure out the right way to write it up. If you have children, very important that you name guardians for your children in your will. Now notice the terminology is nominating. What really happens, God forbid, if you and your spouse pass away, is someone's going to have to petition the court to be named the guardian. But courts give great weight to who it is that you nominated in your will. And that person is given a great advantage. Also, courts don't act fast. In fact, look at us where we are right now. Courts have been closed for over a month and at least more than a month from now. By having a guardian nominated in your will, they should certainly be able to take care of things until they are the official guardian for your children. Also, the best thing in the world is for the whole family, for your extended family to know who is it that you want to raise your children. So this way, the aunts and the uncles and the grandparents, they're aware of your intentions and your wishes. It would be awful for any of us to pass away and leave minor children behind without everyone knowing who is it that you want to raise your children in the event of your death. Now, this subject is what discourages people from doing wills, because it's horrific for any of us to think of passing away before our children, especially our minor children. But it does happen, and we really need to think about and make these decisions and get our documents done. With your will, as remember I use those words, testamentary trust, this is very useful if you have children, but it's not only for parents alone. We may have elderly parents that we're leaving behind, and we're the children, but we want to provide for our parents, but they're not able to take care of their finances anymore. And very common when we have minor children that we create a testamentary trust. And with that testamentary trust, the money goes to the person you name as the trustee. So you do need to name who's going to be the trustee of your testamentary trust. The trustee of your testamentary trust doesn't have to be the same person as you named as the guardian of your children. Sometimes you'll hear the words guardian of person versus guardian of property. The guardian of your children is someone who you want to raise and take care of your children. But if they're not good with finances and money and handling accounts and insurance policies, mortgages, then you may name someone different as your trustee of your trust. But do keep in mind that your guardian of the children and the trustee of your trust, they need to be able to communicate. So you do want to choose people who have good communication skills and people who do get along and trust one another. The guardian of your children and the trustee of the trust for your children, they may be the same person. That is absolutely allowed. But as I said, they don't have to be the same people. Now, as we said, with testamentary trust, not only being able to provide for your children and parents and other elderly persons, but also very useful in providing for any disabled individuals, whoever that may be. The testamentary trust, you can have this essentially, well, really the options are limitless. And that's why I tell people, tell me what you want to do, and then we'll find a way to get there for you. Some testamentary trusts will be for the general welfare in the discretion of the trustee. That's very useful when you have young children. You can't predict what their needs are going to be their whole life. And you appointed a trustee who you absolutely trust to have good judgment. So your trust can just say, I provide for the general welfare. If you want your trust to provide for college education, you do want to specifically say that, because to pay for college education, there is no legal obligation to educate our children beyond high school. So you do want to put in that specific clause that you want to provide for college if you want to. Some testamentary trusts will say, I want to provide an allowance, such as however much amount of money every week or every month. And that absolutely can take place. Many times I see people create this clause providing for an allowance when their children are perhaps older and they can manage their own financial affairs, but they're not yet self-supporting. And that allowance provision is great, because then the beneficiary doesn't have to go to the trustee for money. They have an allowance and they can set up their own budget. You also can create it to provide for future gifts, such as when my child is to get married, I want this trust to provide so much money to them as a wedding gift. Or when my child is buying a home, I want to provide so much money as a down payment. So again, just tell your attorney what exactly you want in your will, what you want in your trust, and they should find a way to serve your needs. And as I said, the options really are limitless as to what you can do with a testamentary trust. Now, moving on to power of attorney. This is, who do you want to handle your financial affairs when you're not able to do so? Keep in mind that the power of attorney is only in effect when you're alive. Upon passing away, the power of attorney is no longer in existence, no longer in effect, and it's the will that takes over. So if you're named as someone's agent in a power of attorney and that person passes away, you can now no longer be paying their bills as the power of attorney. It then, upon death, the paying of bills, the managing affairs goes to the personal representative of the will. But while you're alive, the power of attorney is very useful. You can make it effective immediately. That's very useful if you know you're in a situation in life that you just can't manage your own affairs. Or maybe you absolutely trust your agent and you're fine with making it effective immediately. Or you can make your power of attorney effective upon you becoming incompetent, no longer having the capacity to make your own decisions. If you use this provision to make your power of attorney effective upon becoming incompetent, 2 physicians will be necessary to certify that you're no longer capable of handling your own financial affairs. You also can make your power of attorney be for a specific period of time, such as you're going out of the country or while you're in the hospital. Also, powers of attorney can be for a specific reason, such as a power of attorney to sell my house. Maybe I listed my house for sale and I need to travel and I'm not going to be home when the closing is going to take effect. That's an example of a specific power of attorney. The kind of power of attorney that every single person needs, and this applies to anyone who is over the age of 18, is who should handle your affairs upon you becoming disabled. And that is what we call a very general type of power of attorney. The other document that you very much need is in Maryland, we call it the Healthcare Advanced Directive, also known as a living will. Through your Healthcare Advanced Directive, you're going to appoint a healthcare agent. And I strongly advise you that you're also going to appoint a successor healthcare agent. Just like with your power of attorney and just with your will, if the person you appoint can't, whether they're emotionally traumatized, or they're just not capable of making decisions, or they're not even available, then your successor healthcare agent is the one that would step in. Also, through your Healthcare Advanced Directive, you're going to do healthcare instructions. And again, your Healthcare Advanced Directive will take effect upon you no longer being able to make your own healthcare decisions. We execute a Healthcare Advanced Directive now, but that doesn't mean we give up the ability to make our own decisions. It only means we're appointing someone to make our decisions for us, to communicate with our doctors when we ourselves are not able to do so. Now, the healthcare instructions in Maryland, it anticipates 3 different scenarios. And one is terminal condition when death is imminent, persistent vegetative state, meaning you're not conscious or you're unable to interact with others. And the third scenario is called end state condition. This is when you have an incurable condition that will continue until death, and you have lost capacity, and you're completely physically dependent on others. So we have these 3 different conditions that in Maryland, our healthcare directive anticipates. For each of these conditions, you can choose a different option. And in Maryland, the options are, you can say, I want no medical intervention to extend my life, including no nutrition and fluids by tube, by IV, or by other medical means. That's one of the options. Another option is no medical intervention to extend life, except you do want nutrition and fluids by IV or medical ways. And then the third option you can choose is, I want all medical interventions that will prevent or delay death. Now, there is no right answer to these questions. I can certainly help you with the legal terminology and the definitions, but you may want to discuss it with your spiritual advisor, your clergy person, your rector, your doctor, your family, about how to make these decisions. You are not required to discuss this with anyone before you execute these documents. It's your own personal decision. Other provisions that we can include in the Healthcare Advanced Directive is, what do you want about pain relief? Is it that you want all pain medication, even if it may shorten your life? That is an option that you can put in your Healthcare Advanced Directive. Another is any provision specific to being pregnant. These are really hard decisions to make, but if you don't make the decisions and put it in writing, then the doctors will be forced to make the decisions for you. So you really need to give thought to this. If you are of childbearing years and female, you really do want to think about what would you want if you were pregnant and then came down with a terminal illness. And these are things we could discuss specifically, but it is really important for you to give thought to that. You can also, and this is absolutely optional, but in Maryland, your Healthcare Advanced Directive can provide instructions for after your death, such as organ, tissue, eye donations. Many of us have our Maryland driver's license say, I want to be an organ donor. If you want to be specific, you want to have this as part of your Healthcare Advanced Directive. And you do not put these instructions in your will, because to be honest, by the time we read your will, it will be too late for you to do any of these type of donations. You can also put in instructions for after your death, such as whether or not you want to donate your body to a medical study program. You do not have to do that. It's only an option. But if you do want to do that, you absolutely have to put it in writing through this type of document. Also, you can put in instructions to your family, such as, do you want to be cremated or buried? You also can put in specifics of what do you want your funeral or your memorial service to look like. Now, getting these documents signed. During the pandemic, it has been a challenge. And now in Maryland, we can get these documents signed remotely. Your power of attorney document has to be notarized. Your will and your Healthcare Advanced Directive requires witnesses. And you have to be very careful, because the witnesses and the notary cannot be someone who's going to inherit from you or be responsible for your medical care. It has to be someone who is absolutely neutral. And with respect to getting these signed remotely, there are very specific rules, and the notary has to be approved by the state of Maryland. Just as last week I was certified, and I am now able to do remote notarization, and I do have the technology to help you get your documents signed remotely. You would be in your house, your witnesses can be in their own places, I would be in a different location, and through the technology, we could get these documents all signed, even though we're not in the same room. But you have to follow the rules very carefully. Before, to get a will signed, your witnesses and you had to be in the same room throughout the signing of the wills. Now, as I said, we could do it remotely if we use the technology and we're very careful with it. Now, we got your documents done, they're signed. Where should we keep them? Do not keep them in your bank's safe deposit box. Your power of attorney and your Healthcare Advanced Directive, you want to keep them somewhere where you can access them, because we do not always get rushed to the hospital or get sick during business hours or during banking hours. The same is true with our will. Even though you don't need the will right away, if you have a bank safe deposit box, upon notice of your death, the bank is supposed to seal that safe deposit box until they do an inventory of its contents. So your will could be sitting locked up in your bank safe deposit box and your family cannot get to it. So instead, you do want to keep them in your will in a secure spot at home, or you could keep it with your lawyer's office, so long as that they say they will keep it indefinitely, or you can keep it with the Register of Wills of your county. In Montgomery County, you can register your will there for $5. Then, in order for your personal representative to get it, they would have to go to the Register of Wills and tell them that they are the personal representative in the will, usually best to have a copy, so that they can then get the original out of the Register of Wills. But truly, if you're organized and if you could keep it at home, just let the person you named as the personal representative and the alternate personal representative know where in your home is it saved and where is it kept. With respect to your power of attorney and healthcare advanced directive documents, again, do not keep them in your bank safe deposit box. And you want to keep the originals at home. Do not keep the originals at your lawyer's office because, again, if there's a medical emergency, you have to wait until you can get to your lawyer's office to get the document. But keep them at home somewhere safe and make sure, again, the person you named as your agent and as your successor agent, where are the originals kept? That is the best gift you can give to your family. Not only getting these documents done, but telling them where they are kept. Now, how often should we be reviewing our wills? Every 3 to 5 years. Trust me, you'd be amazed to see how your priorities and your wishes change after, especially 5 years. And even 3 years is a long time when we have young children or parents who are aging quickly. Also, make sure you review your will when you start having children or when you start having grandchildren. Our priorities change a lot. And also, when someone you named as the personal representative, the trustee, or the guardian of your children pass away or become seriously ill. That is definitely a time that you want to look at it and decide, okay, who should I name now? So essentially, whenever anything important happens in your life, look at your will. It doesn't mean you have to make a change, but at least you're going to be confident that your will says what you want it to say. If you want to make a minor change, you can do what's called a codicil, which is basically an amendment to your will. But if you're going to make a big important change to your will, you may want to just create a new will and revoke, void your old will. And that's just something that you would discuss with your attorney as to whether or not is a codicil good enough or should you create a whole new will. Another time to make sure you look at your will is when you retire, or maybe when you enter into a new phase of your life. Also, if you move to a different state, you then want to consult with an attorney in your new residence, your new state, to make sure that your documents are sufficient for that state. Absolutely, I know these are really difficult decisions, but the best gift you can give to yourself for peace of mind, and then you could give to your family, is to get these documents done. So let's open it up for questions. I asked Christina and Kathy to look at questions as they arrived. So I wasn't looking at the chat box or anything like that. So I'm open to questions.
All right. Nancy asks, what if you reside in Maryland and your parents are in another state? Would you pay inheritance tax for the state in which they reside? So
if your parents are in, I don't know New York inheritance laws, but let's say Maryland. And let's say your parents are in another state and they inherit from your will or your child, you know, remember in Maryland, there's no inheritance tax if a parent, a grandparent, a child is inheriting. But let's say a friend of yours lives in another state, they would be paying Maryland inheritance tax because it's the Maryland probate office that is implementing the tax.
Thank you. Are you going to share the notes by any chance? Asks Moses.
Yes, I'm definitely happy to email out the PowerPoint slides. What I'll do is I can make them available to all the Transfiguration members through our listserv. And if you're not a Transfiguration member and you would like these slides, then just email me.
Perfect. And Reverend Kent adds, oh, he's about to add it for himself. I got you.
Go ahead.
Reverend Kent adds that we will have a recording of this lecture. And so you can also access that, I believe, on Facebook and our website. Reverend Kent? Oh, let me unmute you. Hold on. Okay. Can you hear me now? Can we hear you? Okay, you're unmuted.
So I'm recording it, and I will put it into Mary Ellen and Christina's capable hands as to how that might best be shared. We probably don't want to just put it on, put it without attribution on Facebook, given that it has certain legal representations.
Right.
Okay.
But
we will work it out.
Certainly have it like on our website on a page that people could access, but it'll be available after the presentation.
Thank you. Okay, and Jacqueline asks, do you prepare the will and trust at the same time?
If you're doing a testamentary trust, then yes. The testamentary trust is a provision of your will.
All right. Gail and Craig say people should consider donating to Transfiguration or their church as part of their will.
Right. That is absolutely an option. When you're doing bequests, I've seen the most special bequests. You can do a bequest to your church. Transfiguration has, been a recipient of some special donations or in the memory of someone. And I've seen people do bequests to like the Girl Scouts Association or any of their favorite charities. So it is an opportunity to give back to the community by doing your will.
Thank you. And S. Godbout says, we have a power of attorney that we created with downloaded documents. Do we need to have a lawyer to review them to ensure they'll hold up against any challenge in court?
Wait, Christina, can you say that again? I missed the beginning. I'm sorry.
We have a power of attorney that we created with downloaded documents. Do we need to have a lawyer to review them to ensure they'll hold up against any challenge in court?
Yes, I absolutely would recommend that you have an attorney review them. Not only are they written properly, but you want to make sure that they were executed properly.
And isn't there something in Montgomery County, some 19-page document you have to make sure you have that a lot of people don't know about? Is that still in effect?
Well, the good news is there's a short form now, which we much prefer using now. My office started using the short form about maybe 6 months ago on a regular basis, because we find that the short form covers everything that the long form does. The long form, now these are the power of attorney documents that I'm talking about. The long form is useful if you want to give people like some power, but you want to limit it in some ways. So it gives you the ability to customize it much more.
What is the difference between durable power of attorney and other types? Jennifer would like to know.
Durable power of attorney means it stays in effect upon you becoming disabled. And when I say that, many people are like, well, why else am I doing a power of attorney? But picture you're doing a power of attorney specifically because you want someone to, sign your real estate closing papers. Remember the hypothetical I gave, if you're out of town and you want someone to execute your papers for you? If it's a durable power of attorney, it stays in effect even if you were to become disabled. So when we do powers of attorney for the purposes of estate planning, we just say powers of attorney, but they are durable type of powers of attorney.
All right, and same for healthcare advanced directive. Do they, if they downloaded it, should they get an attorney to look it up? I'm skipping back a person to ask God about. The one who asked about the downloaded documents getting reviewed to make sure they'll hold up.
Yes. So you definitely can download the documents. You want to make sure you understand the provisions, the legal terminology, and what is the effect of choosing one option over another. And again, the most important aspect of these documents is making sure that they're executed properly.
Thank you. Okay, we have another question. For medical intervention, those are general scenarios. Is there a way to say, I want these conditions, but I want my executor to decide, given we can't predict every situation that may occur?
That question must be from someone who's looking at the forms, which is great. And I love an educated audience. So the forms actually have one of the provisions, and this is where most people call me up with questions, is it's either you can say, I want my healthcare agent to strictly follow my wishes, or there's another, or the option is, I'm saying what I want, but I'm giving my healthcare agent the flexibility to decide based on the circumstances at the time. Now, I'll be honest, when I hear from some children, they're like, wow, I really wish, mom or dad did not do that, because now really the whole decision making is on me. So I would say if you have adult children and you're naming one of your children, you want to talk with them. You want to see, can they handle these type of decisions? And, would they prefer you just to tell them exactly what to do? Or do they prefer being given the flexibility? So it's a good discussion to have as a family, and especially between spouses. You absolutely want to have these conversations.
Okay. Other than nutrition, what other medical intervention is there? Is this similar to a DNR?
So a DNR is different than a healthcare advanced directive. A DNR, or it's also known as MOLST, M-O-L-S-T in Maryland, has to be signed by your physician. And that is a do not resuscitate order, which is signed by your physician. Many times terminally ill patients ask for that, and also people who are at home, because they don't want like an ambulance, a paramedic to resuscitate them if they're in that situation. And that has to be certified by your physician.
Okay, we have two people. One says that their their attorney lost their mother's will, and another one's mother's law firm dissolved, so it was hard to track down the will. So in light of that, do you still say that you should give the will to your attorney?
If you remembered, I mentioned give it to your attorney if you're not so organized at home. I think, if you're organized and you have a place like a filing cabinet to keep it in, that's probably the best. Now, in the scenarios we heard, if the original will is lost, but you have a copy of the executed one, you can do an affidavit saying, we looked for the original, it's missing, or we know it's gone because someone destroyed it, or a law firm's no longer in existence. And the court can then use the copy as the will. But this is why I tell everyone, if you're doing a new will, destroy all the old copies. One, you might have some bad feelings. Maybe you left your estate to one person and now you decide to leave it to someone else, and there's a copy showing that history of decision making. But also you really want to destroy any copies that are no longer what you want as your will, so you avoid that confusion.
Okay. Another one, I gave the hospital a copy of a power of attorney and healthcare advanced directive during a previous health event. Do I need to give it to them again, or should they have it on file?
I would never count on a hospital having something like that handy and on file. What I tell people to do is whenever you're going into the hospital, bring the original and bring a copy. You're going to leave the copy with the hospital, and someone from the hospital should like initial the copy saying, I witnessed the original. And then this way you hold on to the original. And then if you're in the hospital, send the original home with the person you assigned as your healthcare agent.
And Jennifer would like to know, where do you get a power of attorney document from?
If you can definitely go to the Attorney General's website on Maryland to see the form. And you can use that form. And if you use the form that the Attorney General provides on their website, every financial institution in Maryland has to honor it. But again, I would say, even if you're doing a consultation with an attorney, you want to make sure you understand what it is you're signing, make sure the options you select, you understand, and again, getting it notarized and executed in the right way is the most important thing you need to do.
Thank you. And how is the value of a pension calculated?
So I always say the value of pensions is in the hands of the expert. I've litigated many, many pension values. So typically upon passing away, the plan administrator of the pension will be providing that value.
Okay, and Marcia would like to know, if you have two trustees on a revocable trust and one trustee dies, is that trust still valid with the living trustee?
So that hypothetical, I'm assuming someone appointed two trustees, co-trustees.
Correct.
And that's a great question. Again, it goes against what I typically advise people, just name one person. But I guess it depends if you name your co-trustees Sam and Bob, as opposed to Sam or Bob. So I would have to look into that specifically to give you a definitive answer.
Okay, so Marcia, you can follow up with Mary Ellen when you see her in Zoom or church, whichever comes first.
Okay,
Yeah, I'm definitely happy. I'm happy to look into that. I just don't know off the top of my head.
okay, thank you so much.
All right, and Lloyd, he would like to know, what about IRS and Social Security? Does the power of attorney cover that?
IRS, meaning you're getting your tax returns filed. Your power of attorney does authorize the person you appoint as the agent of your power of attorney to file your taxes and do your tax returns. Yes.
Okay, Lloyd, if that didn't answer your question, just write again into the chat feature. Robin asks, my dad and I were co-trustees on his trust. When he developed dementia, I didn't have him declared incompetent. I just kept paying the bills for him. Is that a good system?
Well, we would need to look at the terms of the trust. Usually the trust stays in place even if the person who created the trust became incompetent, because that's the biggest benefit of doing a trust, is that things can keep rolling during your lifetime, even though you can't handle things yourself. So if it's that type of trust, then you are using the trust exactly what it was created to do.
Great. And Reverend Roney asks, if you live in the state of Maryland and are not legally married and have a significant other, can your family contest your will?
All right. A shout out to Reverend Ronnie. Hello. And Christina, can you give me that question again?
If you live in the state of Maryland and are not legally married and you have a significant other, can your family contest your will?
Well, typical lawyer answer would be you can contest anything.
Anything.
But whether they have, whether they're going to win or not, they would have to challenge the will. So they would have to prove that either you did the will under duress, was your significant other abusing you, taking control of you. It's not only just a significant other or anyone. So the will can be challenged, but they would have to show either duress or that it wasn't executed properly. But as long as, you were not under duress, it was executed properly, you can leave your estate to anyone you want. Sometimes what I do is, like if there's a broken family and someone wants to leave their estate to some of their children, but not all their children, sometimes we will specifically put in the will, I specifically am not leaving someone anything because that's what I specifically chose to do. So this way they can't argue, oh, mom just forgot my name. So if there is someone you're specifically leaving out from a class and everyone else in that class is inheriting, you may then want to specifically say that you intentionally omitted someone from your will.
All right, and we're getting down to the end of the written questions, but if anyone has questions, please write in the chat box and I'll keep going as long as we've got questions. Sharon asks, is there a sample copy of a will that can be provided to follow how it should be written in case you want to take the time to write one yourself before consulting an attorney?
You definitely can find all types of documents on the internet, but you just want to be extremely careful and make even if you think you know it all, I would say at least do a consultation with an attorney to make sure you're doing it properly. These are too important to just try to do on your own.
All right, and Marvin would like to know, can your trust be the beneficiary on retirement accounts?
Yes. So what you would do is you would say, I leave my retirement benefits to so-and-so in trust, or I leave them to the trust of, and you would name the trust. If you're doing that, then you need to make sure you create the trust, meaning you have a document setting forth the terms of your trust.
Thank you. And Jennifer asks, can Mary Ellen provide her email address?
Yes, and I'm trying to remember how to get up the my slides again, because what do you see, Christina? You don't see my PowerPoint anymore, do you?
I see questions.
Oh, okay. So let me see if I get to.
And since we're narrowing down, again, if you have any questions, no matter how small you think your question is, now's the time to ask.
Yeah. Do you see that now?
Yes.
Okay.
Does everybody see it? Thumbs up if you see it.
So there's my email address and phone number. Okay. Great.
All righty. Let's see. I don't see any more questions.
Right.
I'll ask a question. What is
there is one from Marsha Wilson.
Oh, somebody's.
Yes, thank you. Yeah, I put it in at the last minute. Thank you.
Okay. I'm muting you. Sorry. What is a life deed estate and why would someone need one?
Oh, okay. So I assume they're talking about life estate. And what that is you own a piece of property and upon your death, you want someone to be able to continue living in that house for as long as they live. Very common, you're sharing that house with someone else, but you're the only owner of the house. Maybe you're the only earner or clearly the breadwinner. And upon your death, you don't want that person to lose their home. You want them to be able to continue living in that home. So you give them what's called a life estate interest in that real property. But you want to be very careful when you're doing that. So, because you're literally giving them the right to stay in that property for as long as they live, which means the house cannot be sold and distributed to your other beneficiaries until that person moves out or passes away. But I've seen people provide for their significant others, their spouses, their children in a wonderful way and able to keep living in that home. But I've also had cases where it has resulted in terrible litigation when the families don't get along.
Is a durable power of attorney for healthcare the same as a healthcare advanced directive?
I would not use that terminology. I would just say for your healthcare decisions and appointing a healthcare agent in Maryland, do a healthcare advanced directive. Don't call it something else.
Okay, and
Thank you.
distinguish that general power of attorney is different from power of attorney for health.
Same thing. In Maryland, we call, when you want someone to handle your financial affairs, we call that a power of attorney. When you want to, say, appoint someone to be your healthcare agent and make your healthcare decisions, you're going to do a healthcare advanced directive.
Okay, and following up on Marvin's question, Linda would like to know what's the benefit of making the trust the beneficiary on the retirement account?
The benefit would be if you're leaving your retirement account perhaps to children, because no one can own money in their own name until they're over 18 years old. So a benefit would be you would leave it in trust, appoint someone, whether it's your spouse, your friend, whoever, to be the trustee, and then they can use that money to take care of the children. Or maybe you want a disabled individual. Maybe you have a sibling who's disabled and you help take care of them, and you want them to get your retirement benefits, but they're not capable of handling the money themselves. That's an example of creating a trust for your retirement benefits as being very handy.
Okay, and last question from Sharon is, once a power of attorney is done, will it have to be redone yearly? How long is that power of attorney in effect?
The power of attorney document will say whether or not it has a termination date. So like the example of doing a power of attorney just so someone can sign your real estate papers, or maybe handle your affairs while you're out of the country. For those type of powers of attorney, you would put in a termination date. The other option is you specifically say, this power of attorney does not have a termination date. Then it's in effect until you revoke it.
Thank you. Okay, and we have lots of thank yous for great presentation.
Oh, wonderful.
You put everything that's really difficult in a super way to understand. Again, we will have the slides for Transfiguration members so you can get them from them. And we will figure out the legal ramifications of posting it on our Facebook. And again, this was our second series of the ECW's lecture series. Our first one was on senior healthcare issues. This one is on wills and trusts. And I believe we are looking to do a third one in late summer that will be understanding the LGBTQ community. So we'll get you information on that as we put that panel together. And on behalf of the ECW, again, I'm Christina Eaglin, the president, and I would just like to thank everybody for participating today. Your fabulous answers. If you come up with another question, please feel free to reach out to Mary Ellen. You now have her information as well. And I will unmute you if you all want to give a nice rounding applause for Mary Ellen. Stand by.
Thank you.
Well, it was quite the joy doing this. This is my first time.
Thank you so much, Mary Ellen.
Thank you.
Thank you, Mary Ellen.
Mary Ellen. Thank you so much, Mary Ellen.
You're
Great.
welcome.
Thank you.
All right. Well, everyone,
Bye-bye.
Have a fabulous Sunday and stay safe and please stay healthy.
Thank you so much.
Amen.
Thank you.
Say hi to John.
Oh, I will.
Thank you very much.
You're welcome. All right. Thank you, everyone. Bye-bye.
Bye.
Bye-bye.
Thank you.
Maybe you should try calling on.
Why?
I don't know.
Is there an emergency?
Yeah.